The information I'm about to present is not for the faint of heart. You must do your homework, your due diligence. You can't go into court naked. The information I'm about to present is not for the faint of heart. You must do your homework. The court is not just going to hand you anything. Remember, they are a for-profit corporation. A judge is not the court. That's People versus Zajic. The U.S. Supreme Court has stated that, quote, no state legislator or executive or judicial officer can war against the Constitution without violating his undertaking to support it. That's Cooper versus Aaron. Any judge who does not comply with his oath to the Constitution of the United States wars against that Constitution and engages in acts in violation of the supreme law of the land. The judge then is engaged in acts of treason. Having taken at least 2, if not 3, oaths of office to support the Constitution of the United States and the Constitution of the state of Texas, any judge who has acted in violation of the Constitution is engaged in an act or acts of treason. If any judge does not fully comply with the Constitution, then his orders are void. That's In re Sawyer, 124, U.S. 200, 1888. He or she is without jurisdiction, and he or she is engaged in acts or acts of treason. That's U.S. versus Will. What is the penalty of treason? Any judge or attorney who does not report any judge for treason, as required by law, may themselves be guilty of misprision of treason. That's 18 U.S.C. Section 2382. You see, whenever any officer of the court commits fraud during a proceeding in the court, he or she is engaged in fraud upon the court. See Bullock versus the United States. The court has stated, quote, fraud upon the court is fraud which is directed to the judicial machinery itself. It is where the court or a member is corrupted or influenced, or influence is attempted, or where the judge has not performed his or her judicial function, thus where the impartial function of the court has been directly corrupted. End of quote. Fraud upon the court makes void the orders and judgment of that court. It is also clear in well-settled Illinois law that any attempt to commit fraud upon the court vitiates the entire proceeding. That's the People of the State of Illinois versus Fred E. Sterling. The legal maxim that fraud vitiates every transaction into which it enters applies to judgments as well as to contracts and other transactions. That's Alan F. Moore versus Stanley F. Seaver. Also, the legal maxim that fraud vitiates every transaction in which it enters, see also in re. Village of Willowbrook 37. It is also axiomatic that fraud vitiates everything. See Dunham versus Dunham, 57 Illinois. Thomas Stasel versus the federal law. When any officer of the court has committed fraud upon the court, the orders and judgment of that court are void, of no legal force or effect. See Amy in 1994. The U.S. Supreme Court held, quote, this qualification is required if an objective observer would entertain reasonable questions about a judge's impartiality. If a judge's attitude or state of mind leads a detached observer to conclude that a fair and impartial hearing is unlikely, the judge must be disqualified. End of quote. That's Leike versus U.S. 114, SCT 1147. That court also stated in Section 455A requires a judge to recuse himself in any proceeding in which her impartiality might reasonably be questioned. That's Taylor versus O'Grady, 888, F. 2D, 1189, 7th Circuit, 1989. None of the orders issued by any judge who has been disqualified by law would appear to be valid. It would appear that they are void as a matter of law and are no legal force or effect. Should a judge not disqualify him or herself, then that judge is in violation of due process clause of the Constitution of the United States. See the United States versus Shuto, 521 F2D, 842 through 845, 7th Circuit, 1996. Take note, should a judge issue any order after he or she has been disqualified by law, and if the party has been denied of any of his or her property, then the judge may have been engaged in the federal crime of interference with interstate commerce. The judge now has acted in the judge's personal capacity and not in the judge's judicial capacity. It's been said that this judge acting in this manner has no lawful authority than someone's next-door neighbor, provided that he is not a judge. However, you know as well as I do, some judges don't follow the law. Listen real close. If you are a non-represented litigant, and should the court not follow the law as to a non-represented litigant, then the judge has expressed an appearance of partiality, and, under the law, it would seem that he or she has disqualified him or herself. However, since not all judges keep up to date in the law, and since not all judges follow the law, it is possible that a judge may not know the ruling of the U.S. Supreme Court and the other courts on this subject. Take notice, it stated, disqualification is required, and that a judge must be disqualified under certain circumstances. In closing, courts has repeatedly ruled that judges has no immunity for their criminal acts. Since both treason and interference with interstate commerce are criminal acts, no judge has immunity to engage in such acts. All this information can be very vital for you, but if you don't do your homework and due diligence to engage with these courts, your faith is doomed. Remember, knowledge is power, but knowledge not in its proper use is potential suicide.